Yes, hi everyone. This is Dimitris Koulafetis, and during today's session, I'm going to talk about interest. I'm going to talk about the interest the courts in England and Wales can can charge. They can charge on judgment debt. Basically, there are two kinds of interest. There's a pre-judgment interest and there is a post-judgment interest. Both interests are serve different purposes. Although according to recent law, according to the latest case law, uh, it seems that sometimes prejudgment interest can be the same as a post-judgment interest. I mean, can be the same rate. Now, the court, historically, the courts in England and Wales always had the power to award interest. That interest was the interest normally. It was the norm that when there was a judgment debt awarded, which means that a sum was ruled in favor, or damages basically were ruled in favor of one party against the other, the judgment creditor against the judgment debtor, the person who owed basically the debt, or the person who caused the damages, the judgment debtor. He A judgment basically interest was going to apply on the judgment from the day of the judgment. Now, that interest is currently set by the judgments by the it's currently set by the county court interest on judgment debts order 991 article 5, where judgment debt carries interest. The rate of interest shall be the rate of for the time being specified in section 17 of the Judgments Act 1838. And that interest basically is 8%. That interest is basically 8%, and it may from time to time change according to the order of the Lord Chancellor. He So basically the statutory rate of interest, according to the section 17 of the judgment of the Judgments Act 1838, 8%. It can be found right here on the legislation.gov.uk webpage, which says that, reading from section 17, judgment debts to carry interest. Every judgment debt shall carry interest at the rate of £8 per centum per annum from, that means 8% yearly, from such time as shall be prescribed by the courts, by the rules of court, until the same shall be satisfied, and such interest may be levied under writ of execution of such judgment. Now, subsection 2 says, rules of court may provide for the court to disallow all or part of any interest otherwise payable under subsection 1. I'm sorry. So this is basically statutory interest, and it's prescribed at 8% per annum. Now, back to what we were saying before, is that this was interest that applied on the date of the judgment. However, what happened in the case that there was an agreement between parties, and they had set certain rate of interest between them? Would that mean that interest would just automatically cease because because it was the norm that interest was only going to apply from the date of the judgment? What about the contractual interest? What about the time interval between the cause of action when or where damages, from the time that damages were actually incurred, the cause of action actually um, basically the cause of action started, or from the date the contractual sum was made payable, or as provided by a contractual provision between the parties, and the general policy considerations of the freedom of contract. Would that be obliterated? No. The common law provided for exceptions, and one of the exceptions was that contractual interest was could apply on a prejudgment basis. That meant from the date the damages were caused, or that the sum was actually made payable according to the contract, uh, until up until a judgment. From there on, after judgment, uh, post judgment interest was going to apply by is basically currently applying by as said by Section 17 of the Judgments Act 1838, and this is prescribed at the rate of 8%. Now, of course, an interesting consideration that may be raised with regards to post judgment and contractual interest is that what happens if there is a provision in the contract itself between the parties that states that contractual interest will carry on before judgment as well as after judgment. What would that mean? Would that mean that statutory interest was going to apply as well as the contractual interest? Would that mean that the contractual interest was going to replace the statutory interest if the rate of the contractual interest was, let's say, higher than the statutory interest, which is 8%? Was the contractual interest rate going to replace that statutory interest? If that was allowed, was that allowed? Could that happen? Was that fair? Was that unfair? Um, and if what would happen if itself the contractual interest rate was lower than the statutory interest rate? Say the statutory interest rate is currently set at the 8% um, per year, starting from the date of the judgment. What would happen? What would have happened if the contractual interest was lower, was on a 6% basis? Would that mean that the creditor himself would have deprived himself by virtue of such a provision um, of the policy considerations of the legislature to protect creditors from staying out of their money for some time, just by inserting a provision like that? Um, well, a starting point would be that, as was explained also in the decision, this very unique, this very extraordinary decision. And I'm saying it's extraordinary because, quite frankly, I have been I have been thinking about those considerations as well, and I was finding them quite mind-boggling until I encountered this decision, which in which basically decision there was a contract between two parties, and the contract in the contract was it was a section 9HI1, um, which actually went as follows. It said that if a party defaults in the performance of any payment obligation, it will, to the extent permitted by applicable law and subject to Section 6C, pay interest before as well as after judgment on the overdue amount to the other party on demand in the same currency as the overdue amount for the period from and including the original due date for payment to, but excluding the date of actual payment, at the default rate. Now, that meant that this provision actually stated clearly that interest that interest was going to be paid before as well as after judgment on the overdue amount to the other party, and it would cover the period from the original due date for payment to the date of actual payment at the default rate. It was like the rate must have been the rate that was agreed between the parties. Um, so this contractual rate, by effect by virtue of this provision, was going to apply on a post judgment basis. Um, so it was stated quite proficiently in paragraph 12 of the judgment uh, that the starting point is that absent special provision, so if this provision didn't exist, a right to interest merges into a judgment. So let's say that this provision didn't exist and two parties have agreed for a contractual interest between their in the contract. Um, so that the creditor is no longer entitled to contractual interest. Uh, so basically, let's say that if there wasn't such a provision, a creditor is no longer entitled to contractual interest. What it refers to here? It refers to post judgment interest. That means that the court can apply the contractual interest. The court can apply the contractual interest before the judgment, and uh, when the judgment is entered, the right to interest merges into the judgment, and the court has jurisdiction, and it can apply the statutory. It can only apply the statutory interest rate, which is prescribed by Section 17 of the Judgment Act 1838, and also the County Courts Act. Um, the County Courts Act. If I'm not mistaken, it's the County Courts Act 1984, Section 74, which is termed interest on judgment debts, and says that the Lord Chancellor may, by order made with the concurrence of the Treasury, provide that any sums to which this subsection applies shall carry interest at such rate and between such times as may be prescribed by the order. Well, the order is, it could have been order like 991, as explained before. The kind order prescribes for an interest rate that is set out in Section 17 of the Judgments Act 1838, and it's 8% at that time. And to reinforce and to reinforce the fact that Section 74 deals with the post-judgment interest. A reference could also be made to Rule 40.8.3 of the Civil Procedure Rules, termed statutory rate of interest, which basically mentions also, section Rule 40.8.2, power to award interest, mentions that the Judgments Act 1838, Section 17, subsection 1, applies to high court proceedings and states that every judgment debt shall carry interest. This provision envisages a single judgment which constitutes a judgment debt, which can only arise where the judgment itself quantifies the sum which the judgment debtor owes to the judgment creditor. The County Court Act in 1984, Section 74, applies to county court proceedings and states that sums made payable under judgments or orders, including sums payable by installments, shall carry interest as provided for by order see Volume 2, etc., etc. So it basically makes reference to judgments or orders, and if we go actually here, it says that time from which interest, I'm reading from the justice.gov.uk webpage, the civil procedure rules, which are listed on that webpage. time for which interest begins to run. That's post judgment interest, and you see that Rule 40.8, paragraph 1 mentions that where interest is when interest is payable on a judgment pursuant to Section 17 of the Judgments Act 1838 or Section 74 of the County Courts Act 1984, the interest shall begin to run from the date that judgment is given, unless a rule in another part or a practice direction makes different provision, or the court orders otherwise. I mean, it may order that, for example, it may order, for example, that by virtue of that provision that was mentioned in the Standard Chartered account, that which has in effect that the right to interest will not merge into a judgment, that contractual interest may apply instead of contractual interest may actually apply instead of statutory interest, and it may apply before judgment as well as after judgment. And also, the court may order that interest shall begin to run from a day before the date that judgment is given, as we just explained. So those two sections refer to post-judgment interest. Now back to the decision. If the Judgments Act rate of interest is lower, now I'm going to read again so that we fully understand the crux of what was said here, because it's very important to know. It's going to, believe me, it's going to solve a lot of problems when it comes to making a claim at court, especially when high sums are involved. I mean, it's an area which I know involves a lot of technical information, but getting the interest right, for any lawyer out there who's working diligently for his client and wants the best interest. This is a big case, because interests at the end of the day make the big difference in figures, and that works in the best interest of the legal practitioner on the relevant case as well. I forgot to mention that a judgment, in order to qualify for prejudgment interest, must be relevant judgment. That means that it must be over £5,000, and that only if there is a certain provision, if there's a provision in a contract that is regulated under the Consumer Credit, unless there's a provision in a contract that's regulated under the Consumer Credit Act, will contractual interest apply on a post-judgment basis. If there is no such provision, then post-judgment interest will not apply, and there's not going to be post-judgment interest. If there's such provisions, however, I'm talking about exclusively about contracts that are regulated under the Consumer Credit Act, 1974. They are, if there's such a provision, then despite the fact that statutory interest doesn't apply, this provision is not going to be deemed unfair, and the contractual rate is going to apply before judgment and after judgment, post-judgment as well. It's not going to be termed unfair, and that was mentioned in that was actually the whole the whole area that was solved in this other very important case regarding interest rates with regards to certain contracts, called the First National Bank versus the versus D/G of Fair Trading, the Director General of Fair Trading, if I'm not mistaken. 2002 1 AC 481 is basically the citation. It's basically, and it went all the way up to the House of Lords, of course. Now, there are this three. I know that I have been waffling, but it's such a big topic, and I need to mention all those considerations. And now there is under paragraph and under paragraph 12 of that decision, it was very proficiently mentioned that the starting point is that absent special provision, a right to interest merges into a judgment so that the creditor is no longer entitled to contractual interest. Right. So if there is a right to, if there is no provision of the like, which basically states that contractual interest is going to apply after judgment at the rate of the contract, then a right to interest merges into a judgment, and it follows that if the Judgment Act rate of interest is higher than the contractual rate, the creditor receives a sum higher than to which it would have been contractually entitled. In that case, the creditor will be awarded a statutory interest by virtue of Section 17 and Section, as I mentioned before, the Section 74 of the County Courts Act, and Section 17, more importantly, of the Judgment Act 1838, at an 8%. Now, if the he will be receiving, it says that if the Judgment Act rate, that's the statutory rate, is higher than the contractual rate. Let's say the 8% is higher, it's an 8%, and let's say the contractual rate is like 6%. The creditor receives a sum higher than that to which it would have been contractually entitled. So he will receive at one point the 5%, and then from the point of judgment onwards, he will be receiving rate at 8% annually, which is going to work in his favor, since the statutory rate is higher than the contractual rate. Now, conversely, if the Judgment Act rate, that's the statutory rate of interest, is lower than the contractual rate, let's say if the statutory rate, which is set at an 8% annually, is lower than the contractual rate, let's say the contractual rate is like 10%, 11%, 12%, then the creditor receives a lesser sum than that to which it would have been contractually entitled. That is if there is no provision. Now, if there is such a provision, the usual purpose of a contractual provision preserving a right to interest post-judgment is to prevent that merger. So such a provision which preserves a right to interest post-judgment prevents that merger. The provision states, as I explained before, the provision 9H1, paragraph 1, basically provided that the default interest was going to apply post-judgment, pre-judgment as well as post-judgment. So there was not going to be a certain pre-judgment interest applying from the date that the contract provided for. The sum was basically made payable whatever date was agreed between the parties under the contract, and the date of the judgment, and then from the date of the judgment thereon, for the statutory rate to apply, because there was no merger thanks to that provision. That's what I'm trying to explain. However, it would have been highly prejudicial. If such a provision was inserted in order to favor the judgment creditor, if it would have hijacked him of his very right to have to have contractual to have a statutory interest applied post judgment was higher, was basically higher than the contractual interest which was agreed between the parties. Let's say that there was such a provision, and if there was such a provision and the rate was 5%, the contractual interest rate agreed was 5%, that would not have been right and fair for the creditor who would have been operating as would have been acting to his own self distraction, so to speak, to suffer the consequences of that provision and not be protected by and deprive himself of the protection of the statutory rate, which could have been higher. Let's say if it's an 8% and the contractual interest rate was 5%, it would have been unfair for him to be deprived of the statutory interest, because let's say at a point that the contract was agreed, the statutory interest was lower. That was not was what was intended between the parties. So it does not operate to deprive the judgment creditor of the protection of the statutory regime of interest rate at 8% if the 8% is higher than the contractual interest rate. And this is also, and I just explained the third paragraph of subparagraph of paragraph 12 of the judgment, which says, but the incorporation of such a term is not generally intended to deprive a debt ordered to be paid by the court of its status of a judgment debt, and the creditor of its statutory right to payment of interest under the Judgment Act. Paragraph 13 states, to put it another way, the underlined phrase in section 9 HI1 is not to be construed as an agreement that SCB would not be entitled to Judgment Act interest. SCB was the judgment creditor in that case. Now, now contracts were not the only thing. I just want to go back and say that contracts were not the only thing that was accepted by was a common law exception to applying a prejudgment interest. There were negotiable instruments, certain obligations relating to the real and personal property, and also while interest couldn't be claimed under the first head of Headley versus Baxendale, it could be claimed under the second if there was a delay which showed which proved a loss on the part of the person who suffered the damages, the judgment creditor as well in that case. As the law evolved, it provided for statutory provisions which allow for prejudgment interest to be applied. This is section 35A of the Supreme Court Act, and and also it's the Supreme Court Act, and also section 69 of the County Courts Act 1984. Section 35A is called power of High Court to award interest on debts and damages, subject to rules of court in proceedings. Whenever instituted before the High Court for the recovery of a debt or damages, there may be included, and that's a magic word, included, not as opposed to section 17 of the section 17 the Judgment Act 8038, which states every judgment shall carry interest rate, which refers to post-judgment interest. I'm basically differentiating them due to practical considerations, as was seen by the the complex problems that may be involved between the interplay of contractual provisions and statutory post-judgment interest rates applied, as was manifested in the case of Standard Chartered Bank, Selling Petroleum Corporation, regarding the interest. Basically, that was a special decision regarding the interest, and here it says included, which means it is part of the sum. It's not after the judgment. It doesn't say carry. It basically includes. It's basically it is included. Has become part of the sum of the judgment debt, because I know that it's a technical term. I mean the I know that a lot of you will say that yes, but post judgment debt includes that amount of money. Post judgment debt carries interest, and interest is going to be to apply on the post judgment debt. But what I'm saying here is that pre-judgment interest is basically calculated on the post-judgment debt. So that's why it's included, because the judgment debt is basically transforming into a sum together, which is amalgamated with the interest, and on which post-judgment interest is going to apply. That's the whole crux. That's why there's a distinction made, even though it's all interest that generally speaking, that the court awards. That's why a distinction is made. So it states that at such rate as the court thinks fit, or that's again pre-judgment interest. It was post-judgment interest, would have been 8%. Would have been an 8% statutory interest, or as rules of court may provide, on all or any part of the debt or damages in respect of which judgment is given, or payment is made before judgment, for all or any part of the period between the date when the cause of action arose, and in the case of any sum paid before judgment, let's say there was, A owed to B money, and he paid that money before judgment was given, and the date of the payment. So the cause of action and the date of the payment, and in the case of the sum for which judgment is given, the date of the between the date of the call of action and the date of the payment, in relation to a judgment given for damages for personal injuries or death which exceeds £200, subsection 1 shall have effect, with the substitution. Let me just magnify that for easier view. With the substitution of shall be included for may be included, and with the addition of unless the court is satisfied that there are special reasons to the contrary after given were first occurring. Another important provision states that here the discretion of the court when awards prejudgment debt, the defendant pays the whole debt to the plaintiff. Otherwise than persons with judgment in the proceedings, the defendant shall be liable to pay the plaintiff simple interest at such rate as the court thinks fit, or as rules of court may provide, on all or any part of the debt for all or any part of the period between the date when the cause of action arose and the date of the payment. And this is a very important provision here, that that interest in respect of a debt shall not be awarded under this section for a period during which, for whatever reason, interest on on the debt already runs. So if there is a contractually agreed interest between two parties, uh, and it's already running, say 5%, then interest of a debt shall not be awarded under this section for a period during which, for whatever reason, interest on the debt already runs. So if there's a 5% interest, let's say, it's a contractual interest, has been agreed between two parties, the court shall not award, it cannot award a different rate of interest. That's what it says here. It needs to stick with a 5% interest on the prejudgment basis. And on the post-judgment basis, if on the post-judgment basis, it is going to if the according to the precedents, according to the case I just mentioned, if the decision, if there's a provision which states that the 5% interest that was agreed will carry on after the judgment, this of course will not, the court will not allow for that provision to backfire against a creditor and depriving of the statutory interest rate, which currently is 8% and would be higher than the example, the imaginary scenario that we just mentioned. And also the County Courts Act 1984, section 669, power to award interest on debts and damages, basically states more or less the same things, but only with relation to the power of county courts to award prejudgment interest as opposed to the High Court. So this is the seminar actually session comes to an end. I hope that you enjoyed it. I know that it has been quite mind-boggling for you, but it is an important area of the civil procedure and of the stage of pleadings, because it makes a difference in numbers, and it's good to do the legwork beforehand and know what you're going to claim. Thanks a lot for watching, and in the next session we could talk a couple of things more about interest awarded by courts in England and Wales. This is Dimitris Koulafetis. I'll see you in my next session.